So good morning, good afternoon, good evening to all the panelists and attendees gathered here. It takes my immense pleasure to be the host of this session as well as moderating it. And before starting it, I'll just give a brief introduction about our KFCRI and our associate IIT ARB. This is the last day of our 3-day masterclass. We have a wonderful panelist who are the resource persons of KFCRI as well. So we have Mr.V.Inbavijayan, who is the project advisor of KFCRI, and we have Mr. Engineer Sivaraman, who is the Secretary General of IIT-R, and we have our stellar panelists, Mr. Johan Bayers, and Mr. Damien James, and Ms. Chandler. And we do have our other managing committee members, Mr. Shwetan, GS, and Mr. Shahrukh Kumar. And a brief introduction about KFCRI. KFCRI is one of its own kind institution, and it's fast growing globally. We function in 3 dimensions. One as an institution, and as a role of institution, we have our own rules for all the area mechanisms. The other as in think tank. As a think tank, we conduct so many events and trainings for the purpose of promoting the noble objective of area. And other is an accreditation body. We train and disseminate knowledge to the various professionals. And these are all the main functions of KFCRI as of now. So it's one of the main purpose of think tank. This is the interesting of 3-day masterclass. So the other associate for KFCRI is IIT-ARB. A brief introduction is, it is established in the year of 2003. There is the Indian Institute of Technical Arbitrators with its headquarters in Chennai, India. And it's an all India non-profit professional body of engineers and architects. And it has been registered under the Societies Registration Act 1975. And what is more interesting is that it is a single platform to all the technical arbitrators, financiers, planners, developers, architects, all the engineers of all the disciplines. So it's glad to have a long association with IIT-ARB. And a brief introduction about our main panelist, Mr. Johan Bayers. So Mr. Johan is an advocate and a member of Keating Chambers. And Mr. Bayers has practiced as an advocate at the Cape Town Bar since 1992, specializing in construction, engineering, and commercial disputes, often of substantial commercial value and involving a complex technical, factual, and not more than often legal issues. And what is more interesting and predominant is he's admitted to appear in the courts of both South Africa and the Kingdom of Lesotho. So Mr. Johan has also joined the Keating Chambers as an international member from the year of 2017. And about today's session, this is day 3 of this 3-day masterclass, and the topic of international arbitration and the delay analysis. And the session will be of several divisions on analyzing the claims of delays and the different contracts and the result of the pandemic and what are the steps can be taken. So it's great to have all the wonderful panelists gathered here, and thank you all the attendees for showing your enormous interest. Mr. Johan, please. Over to you.
Thank you very much for the kind introduction. Thank you very much for that kind introduction and for having invited me to speak. I'm very honored to speak to all of you today, and afternoon to all of our participants this afternoon in this webinar. Let me share the screen. See if we get this right. Right. Is my screen live?
Yes.
Yeah. Excellent. So the broad topic that I'll be addressing with you today is international arbitration and delay analysis, but more particularly, the main themes that I'll be addressing is the prevalence of delay in construction projects, the approach of construction standard forms to claims for delay, how standard forms respond to the COVID pandemic, what is the response of different legal systems to claims for delay and to the effects of the pandemic, then what is the correct approach that should be adopted to the analysis of delay in international arbitration, and what steps should advisors and parties consider within the context of claims for delay, and particularly within the context of the COVID pandemic. Now, delay in construction projects is a perennial problem. Infrastructure projects are notorious for overrunning on time and cost, and this has serious economic and political consequences. It has serious economic consequences for the parties to the contract, but it has very serious, often economic consequences to the country where an infrastructure project is being conducted as a whole. Some study data to demonstrate how prevalent delay is in infrastructure projects and the extent of it. In Saudi Arabia, 70% of projects experience time overruns, with an average of between 10 to 30% overrun on the original duration. In Qatar, 80% of infrastructure projects suffer from delay, with an average delay of 25%. In India, this is quite a big study. Out of 894 projects, 82.33% of projects suffered time overruns, and delays were one of the crucial causes behind cost overruns. In Africa, the situation is very much the same. 50% of respondents reported delays of more than 6 months, and more than a third indicated projects that went 10 to 50% over budget. South Africa, particularly our government projects, not so much our private projects, but the government projects are a complete disaster. We have delays on our Medupi and Kusile power station and a number of big infrastructure projects of a number of years. Time overruns of 300% to 400% of the original estimate. And those projects are presently running at 300% over budget, and they haven't yet been commissioned. This has debilitated our economy and has vastly increased our government's debt ratio. So delays in infrastructure projects is an international problem. It has major cost implications. It has national economic and political effects, and claims for delay and associated time-related compensation are probably the most prevalent source of disputes on construction projects. Now, turning to standard forms, I don't know how many of our participants are well-versed in construction, and for those that are, I apologize, but I thought I should start out with an introduction to standard forms before I deal with the manner in which standard forms deals with specific issues. Standard form construction contracts are in widespread use in the construction industry. What are they, and how do they provide for claims on account of delay? Now, there are a number of suites of standard form construction contracts available for infrastructure projects. These are published by various national and international organizations or professional bodies. Some standard forms are more popular than others. The World Bank supports the FIDIC suite of standard forms, and these have become the most widely used international construction standard forms for infrastructure projects throughout the world. But why would one use a standard form? Well, it provides a set of standard terms and conditions which are tailored to the specific procurement and delivery model for the project. So FIDIC, for example, has a red book that is tailored for a procurement method which involves owner design and contractor build, but it has a yellow book, for example, where the contractor does both the design and build and so on. The forms provide for the most commonly occurring risks in construction, which in the absence of specific agreement could be destructive of the contract. And we'll see this within the context of the COVID pandemic, for example. The idea with standard forms is that they are to provide a balanced and equitable risk distribution regime for the contractor and the employer to foster better pricing. And they are also intended to amend or supplement the normal common law rules, because often the application of a common law rule has a binary outcome in terms of the contract being invalidated or cancelled. And what standard forms attempt to do is to provide a more graded outcome to certain risk events occurring. And now turning to just general common law principles as background context to what we will be dealing as it relates to time for completion. Where the contract has no, this is English common law, where the contract has no express provision as to time for completion of the works, it is implied that the contractor is obliged and entitled to complete the works within a reasonable time. But of course, in the context of large projects, what a reasonable time would be in practice is very difficult to quantify. Where a time for completion is specified, the contractor is entitled to use that time and obliged to complete within that time. where a contractor is prevented by an act of the employer to complete within the time specified, time becomes what we say at large. And when we say time is at large, it means that the contractor has to perform within a reasonable time, i.e. not by a specific date. So the moment you have, even if you have a specified date in terms of the common law for completion, when an act of prevention occurs, the specified date is the duty to comply by that date is removed. And instead, the contractor now has the duty to comply within a reasonable time. And this makes it impossible to couple penalties to a failure by the contractor to complete timelessly, because you can't couple penalties to a reasonable time. Penalties have to be coupled to a specific date. So one of the main purposes that standard forms attempt to achieve is to prevent time from becoming at large, so that time within the context of a construction project can be managed, and that there is a stick with which the contractor can be persuaded to, in terms of penalties, to complete timelessly. So the general approach of standard forms to time for completion and delay is that standard forms identify a specific time for completion, and a failure by the contractor to meet this time for completion is visited by penalties for every day the project is delivered late. And then the standard forms provide a mechanism for the extension of the time for completion, which accompanies also a relief from penalties for the period of extension, and additional payment to the contractor of time-related compensation in respect of the time period of the extension. Now, it does this by providing a claim mechanism. The right to claim an extension of time is subject to compliance by the contractor with a prescribed claim procedure. It must normally submit in predefined time periods, and usually the failure to comply strictly disentitles the contractor from relief for that delay. The contract specifies the risk events for which the contractor is entitled to make a claim for an extension of time, and usually if the delay doesn't qualify under any of the specified events, the contractor bears the risk of that delay. So just as a general proposition, one may class delays in construction into three broad categories within the context of how standard forms deal with them. The first is a delay that occurs as a result of an employer's risk event or an employer's breach. For example, a failure to provide timeless access to site. The second class is where the delay is attributable to a contractor's risk event. For example, a contractor's failure to timelessly place an order for a time-critical component, or a failure by the contractor's subcontractors to perform timelessly. And then thirdly, events in respect of which neither the contractor or the employer is at fault. And for example, that is the COVID-19 pandemic is an example of such an event. And the usual response of standard forms, and of course this differs between various standard forms, but the usual response is that in the case of the first category, where the delay is occasioned by an employer's risk event or breach, the contractor is entitled to an extension of time and additional compensation. If the delay is due to a contractor's risk event, the contractor is neither entitled to an extension of time nor to additional compensation. And where the delay is occasioned by an event for which neither the contractor or the employer is at fault, the contractor obtains an extension of time, but it's cost neutral in the sense that the contractor does not at the same time also obtain additional compensation. But of course, as I've said, this risk distribution regime differs in respect of particular events between various standard forms. So I thought it would be useful to at least provide one standard form as an example to demonstrate how standard forms in general deal with delay. And I selected the FIDIC Red Book. Now, the FIDIC Rainbow Suite of standard forms is published by the International Federation of Consulting Engineers. FIDIC is an international standards organization for the engineering and the construction industry. This suite enjoys World Bank support and is used throughout the world on large infrastructure projects. And I've selected the Red Book because this Red Book is the classic form that's used For traditional procurement, that is where the employer designs the works and the contractor builds it. So it's a very standard type of contract. And the general principles governing delay claims in terms of the Red Book are similar across many standard forms. But I thought it would be a good book to use, or a good standard form to use as an example. So within the context of the Red Book, as it concerns time for performance, the contractor is obliged to commence the works within 42 days of the letter of acceptance. And then the contract provides that the contractor must complete the whole of the works within a stipulated time for completion. The contractor is liable for an agreed sum of delay damages to the employer if it fails to complete within the time for completion. And clause 8.4 of the Red Book provides that the contractor may, in certain circumstances, become entitled to an extension of time for completion. Now, clause 8.4 identifies a number of categories which are available to a contractor in order to claim an extension of time. The first is one of the most prevalent things that happen on a construction project is the contractor is required by the engineer to do additional work, a variation. There's a provision for an extension of time in the case of exceptionally adverse climatic conditions. Then there's a specific category that deals with unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental action. So we see that this is of particular relevance to the COVID pandemic. It is also, extensions of time are also available on account of any delay caused by or attributable to the employer, the employer's personnel, or the employer's other contractors, or, and this is the wide clause in FIDIC, a cause of delay giving an entitlement to extension of time under a subclause of these conditions. And as we'll see, there are a number of clauses distributed throughout the Red Book which deals with risk events for which the contractor where the contract specifically states for this risk event, the contractor is entitled to additional time and or additional cost. Now, if a contractor is granted an extension of time, that means that it is absolved from penalties for the period of the extension. But the fact that a contractor obtains, in terms of the Red Book, an extension of time does not necessarily mean that the contractor also is entitled to recover additional time-related costs on account of the delay. Because in terms of the Red Book, the contractor's entitlement to additional costs, additional time-related costs, is dependent on the extent to which the contract affords an entitlement to such cost for the particular risk event that gave rise to the delay. Now, the mechanism that the FIDIC prescribes is set out in clause 20, and the claim mechanism to obtain an extension of time or additional payment requires that the contractor must give notice to the engineer no later than 28 days after the contractor became aware or should have become aware of the event or circumstance. And if the contractor fails to do so, the employer is discharged from all liability in connection with the claim. So there's a very harsh time bar in the Red Book, which is not uncommon in construction. In fact, it is more common to find in standard forms for claims on account of for additional time and costs that there is a time bar than cases where there aren't. Now, when a contractor delivers this claim, the first port of decision making is the engineer, who must then consider the claim, grant an extension of time or refuse it, and consider additional payment to which the contractor may be entitled under the contract for the event complained of. If the contractor is dissatisfied with the engineer's decision, he can elevate that dissatisfaction to a dispute adjudication board, and if he's dissatisfied with the dispute adjudication board's decision, there is a process of amicable settlement, whereafter the standard form of dispute resolution in terms of the FIDIC suites is international arbitration. And on international arbitration, arbitrators have the full unfettered power to open up, review and revise any determination or certificate that have been issued by the engineer or the dispute adjudication board. Now, how does one quantify the time and money that is to be awarded to a contractor on account of a claim for extension of time or delay? Now, generally speaking, I think this is quite standard across most standard forms. A contractor is entitled to an extension of time for a period that is commensurate with a delay that suffered to its critical path to completion. And that is a topic of particular complication, which I'm sure Damien has addressed with you in quite detail. And I've got in the last section of my presentation today, where I deal with prospective and retrospective approaches to the analysis of delay, we'll be revisiting this particular concept. And then the contractor's entitlement to recovery of additional costs suffered on account of the event is recoverable to the extent that the contract expressly allows for such cost entitlement in respect of the event complained of. Now, within the context of FIDIC's response to COVID-related claims, there are 4 clauses that are of particular relevance. The first 3 sub-clauses deal with force majeure and the consequences of force majeure, and the last one, 13.7, that I refer to in this slide, deals with the consequences of changes in legislation, which is also relevant within the context of the government-imposed lockouts that we had on account of the pandemic. Now, FIDIC has a particular definition of force majeure. It is an exceptional event or circumstance which is beyond the party's control, which such party could not reasonably have provided against before entering into the contract, which having arisen, such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. And we see, if we test the COVID pandemic against these provisions, my view is that the COVID pandemic certainly qualifies as a force majeure event in terms of this definition. Clause 19.1, the definition clause of force majeure, further provides certain examples of what these exceptional events or circumstances could be, but this is not a closed list. One of the examples is the last example, sub 5 of 19.1. It refers to natural catastrophes, and then it says such as earthquake, hurricanes, typhoons, or volcanic activity. Now, it's not 100% clear to me whether one may consider a pandemic to be a natural catastrophe. But as I say, it's not a closed list, and the COVID pandemic definitely qualifies as a force majeure under the main qualifying section. So what are the consequences that FIDIC accords a force majeure event? The FIDIC says, and this is in clause 19.4, that a contractor who suffers delay on account of such an event is entitled to an extension of time. Then, if the force majeure event is one of the kind described in the first 4 bullets of the list in 19.1, the contractor gets costs. But if it's not in the list, or not in the list of examples that clause 19.1 refers to, or for example is item 5, which is the natural catastrophe one, the contractor is not entitled to payment of costs. So if one applies this to the COVID pandemic, the COVID pandemic is not specifically listed. If it's a natural catastrophe, you get an extension of time, but you don't get cost. And because it qualifies under the main definition of force majeure, you certainly get an extension of time, but because it's not part of the first 4 bullets of 19.1, you don't get cost. So bottom line, in terms of the treatment of COVID as a force majeure event, as it relates to extensions of time and cost, is you get an extension of time, but you don't get cost. So earlier, when I dealt with the 3 broad categories, I mentioned that if it is a category for which an event for which the employer was responsible, then the contractor will get time and cost. If it's one for which the contractor was responsible, then the contractor gets nothing. And if it's one where the event occurred neither at the fault of the employer or the contractor will get an extension of time and not cost. Well, you'll see that this is in the context of the pandemic per se, how FIDIC deals with it as well. But there are other consequences of a force majeure event that FIDIC also provides for. So if the force majeure event delays substantially the execution of substantially all of the works for a period of 84 days continuously or 140 days in multiple periods, either party may terminate the contract, and the contract is entitled to be paid for the work done up to that point. There's also a general release provision which applies where if the facts are that the force majeure event made it impossible or unlawful for either or both parties to fulfill their contractual obligations, or under the governing law of the contract, the parties were entitled to be released from further performance, then either party is entitled to deliver a notice to terminate the contract, and the contractor gets paid for the work done up to that point in time. The second provision in FIDIC that is unrelated to the force majeure provision, but relates to some consequences of the pandemic, is clause 13.7. And what clause 13.7 does is it makes the employer responsible for changes in legislation. And that those changes in legislation could even be a change in the interpretation of legislation that occurred after the date upon which the tender was received. In the case of the pandemic, we have had across a broad front throughout the world responses by governments which introduced legislation or regulations which imposed a lockdown on the movement of persons and the economy. Now, that legislation, these rules, legislative rules, are rules which qualify under clause 13.7, and in the case of such legislation being issued, FIDIC allows both an extension of time and the payment of cost that was incurred by the contractor as a result of such legislation. So what you find is that if you have suffer under the consequences of the pandemic per se, without a lockdown, you would be entitled to time but not cost. But for the period of time during which you as the contractor had to suffer under a lockdown and suffered a delay as on account of the lockdown, you would be entitled to both an extension of time and the cost that is attributable to the lockdown itself. So the COVID-19 pandemic qualifies under FIDIC as a force majeure event, and as such entitles the contractor to an extension of time but not cost, the right to terminate where the event persists for more than 84 days, and release from the contract if this remedy is provided by the substantive law of the contract. And then secondly, where the government through legislation or regulations impose a lockdown, the contractor is entitled to recover the time lost through the lockdown as well as the additional costs suffered on account of the lockdown. The interesting thing is that, and perhaps it is because COVID was such an unusual event, such an exceptional event, is that the response to COVID isn't uniform among standard forms. Of course, when this event occurred, as I act for large institutional employers in South Africa, the first thing they wanted to know was what is the impact of COVID going to be in terms of the standard forms that they employ, and what they wanted to do, and it was a sensible, I guess, approach, is to try and deal with the COVID pandemic through all of the procurement contracts in a standardized way. And the difficulty was, once we started looking at the various standard forms that they had in use across about 2,000 projects, there were about 4 different standard forms in use, and in some cases, various editions of particular standard forms, and all of these had a different dispensation when it came to COVID. So what they had to do was to deal with the pandemic in respect of each standard form separately. Now, just as an example, we have in South Africa what we call a JBCC standard form. It's a standard form building contract, which is the widest or the most prevalent standard form building contract in Southern Africa, and it's also used elsewhere in Africa. It provides for an extension of time for the pandemic as a force majeure event, but doesn't afford the contractor any cost compensation. And there's no separate provision in the JBCC for an extension of time or additional cost compensation on account of a change in laws. So the lockdown didn't give you anything. You would have to go on the basis of the pandemic, but then you'd only get time and not cost. The other standard form that we have in South Africa is the General Conditions of Contract, the GCC. And that form, interestingly, provides specifically for epidemic, famine, or plague as accepted risks for which the contract is entitled to both an extension of time and cost. So the point is that one needs to have regard to the specific wording of a particular standard form if one is to establish what protection that standard form provides to a contractor on account of the COVID pandemic and the lockdowns associated with it. But there is an additional issue that one has to always take into account when you are looking at an international standard form which is used in various different jurisdictions with different legal systems. And that is the influence of the substantive law of the contract on the remedies provided by standard forms. All standard form contracts are fundamentally affected by the party's choice as to the applicable law of the contract. The governing law of the contract regulates the legal requirements for contract formation, known as the validity of the contract, the principles relating to contract interpretation, and through the application of legislation and public policy, the manner in which the contract can validly be executed and enforced. The substantive law of the contract also often operates alongside the standard form in terms of the remedies that are provided and may supplement or qualify the remedies afforded to a party in terms of the standard form. Where the contract does not contain an exclusive remedies clause, a party often has a choice as to whether it wishes to pursue a claim under the contract or under the substantive law. And that choice is often a very important one, because the common law often generally doesn't have, apart from a limitation of actions, like prescription and so on, doesn't have a time bar provisions or time limitation clauses of the same nature as those under the contract. And as Keating indicates in their book, it is often a situation where a party may forego a claim under the contract because that claim may be time barred, and rather pursue an alternative remedy under the substantive law of the contract because that may not be time barred. So as a consequence of the fundamental influence of the substantive law of the contract, the remedies available to a party in terms of the FIDIC Red Book on account of a particular event in one jurisdiction may not necessarily be available in another jurisdiction. And there are various ways in which the substantive law of the contract impacts upon the remedies that are provided by standard forms. And I'll deal with three examples. The first is the employer's right to claim penalties for delay. So we've said that a major focus of standard forms when it comes to management of time on a project is to provide a specific date for completion, and then to penalize the contractor where the contractor doesn't make that date. Now, penalties for delay, English law does not like penalties. To be enforceable under English law, the penalty, if I can put that in inverted commas, must be a genuine pre-estimate of damages for delay. In the Czech Republic, for example, the principle of claiming penalties on account of delay is problematic per se, and you have to do certain amendments to the FIDIC to allow for penalties to be claimed as a lump sum under a particular portion of the Czech Civil Code. In France, the right to claim penalties is enforced, but the courts may both increase or reduce penalties looking at what the actual loss was that was suffered by the innocent party. And in South Africa, for example, the right to claim penalties is generally enforced, but there's legislation which makes the penalty subject to reduction by the court where the penalty is in excess of the loss actually suffered. So public policy plays a role in rebalancing the risk distribution on the contract, and in particular when it involves issues of penalties for delay in various jurisdictions. Similar principles apply to the employer's right to rely on the time bar. So we've referred to clause 20.1. We've said that in terms of FIDIC, if you apply for, if you submit a claim for for an extension of time or additional costs, then you have to comply with the time barring provisions of the clause. Now, time bars are enforced in English law with very little compunction. However, in civil law systems, which recognize good faith, reasonableness, fairness as principles and values that underpin all contracts, unreasonable or unfair time bars might not be enforced in a particular case. In South Africa, for example, we have a hybrid system. We have an originally Roman Dutch system overlaid by English common law. In our system, time bars are enforced, except where the time bar clause is per se unreasonable. For example, if the time bar clause says you have to submit your claim within 2 days, that would be something which we would consider to be per se unreasonable, or where even if the clause itself isn't unreasonable, a party's reliance on the time bar is mala fide, or in the circumstances of the case, it would be unreasonable or unfair to allow the time bar to be enforced. And when it comes to time bars, one has similar provisions or similar principles applying in civil law countries, the Middle East, for example, where the court would look at the extent, the advantage to be gained by a party from notification, as opposed to the harsh consequences, the disproportionate consequences of the effect of the time bar. And in the Middle East, time bars are less enthusiastically enforced, for example, compared to what the position is under the common law. Then issues like events like COVID and force majeure events, civil law systems recognize and provide remedies for circumstances of force majeure. These may result in the release of parties from the contract, or, for example, under German law, on the basis of a doctrine of collapse of the basis of the contract, courts are empowered to adapt contractual terms to account for the changed circumstances. So in German law, if an event occurs which fundamentally destroys one of the pricing assumptions in the contract, so that the contract has become much more expensive to execute on account of an event that occurred subsequently, like COVID, for example, a court may be approached to provide an adapted contractual term that properly accounts for the changed circumstance. And that is a public policy attempt to mitigate the otherwise harsh and unfair effect that a contract term might have. Other systems don't necessarily recognize force majeure, but do recognize and release parties on account of supervening impossibility of performance. That, for example, is the South African legal position. These remedies, force majeure and COVID remedies and remedies on account of supervening impossibility of performance, may coexist with the remedies provided in a standard form. And they generally do, unless the standard form has an exclusive remedies clause which excludes the operation of other remedies than those provided in the contract. And even such a clause would, in many jurisdictions, be considered to offend public policy. So let me turn then to deal with the last section. And this is it's a change of tack. It's a different topic altogether. It deals with the approach, the correct approach to the analysis of delay in international arbitration. Now, we've discussed the fact that construction contracts allow for contemporaneous claims for extensions of time and costs on account of employers' risk events, and that the contract administrator, in the case of the FIDIC, the engineer, would adjudicate these claims whilst the project is ongoing and before the effects of the employer's risk event has been felt. So you often have a situation where, say, for example, you have a variation to the roof of a building that's instructed at a point in time long before the roof is ready to be constructed. The contractor is obliged to, if he wants to claim for an extension of time, to claim that within 28 days of becoming aware of the event. So he has to put in his claim a very long time in advance of when he'll actually be experiencing the delay, when he'll actually be building the much more complicated roof and expending more time in doing so. So you often have the situation where the contract administrator has to adjudicate a claim whilst the project is ongoing and long before the effects of the employer's risk event has been felt. But on arbitration, which is usually occurs after the project's been completed, the question is, should the claims for delay be assessed with reference to what was known when the claim was made originally, or with reference to what had actually happened during the course of the project, the as-built data? And this is a vexed question which arises very often in claims for delay. So the genesis of this debate is that, so let's just deal with the two different approaches. So the approach that is applied when the claim is contemporaneously assessed before the effects of the delay has been felt is generally referred to as the prospective approach. So the prospective approach involves an analysis of the likely effects of a delay, which is prepared in advance of the occurrence of the delaying events. The American Association of Cost Engineers describes it as, says, prospective analyses are performed in real time prior to the delay event or in real time contemporaneous with the delay event. In all cases, prospective analysis consists of the analyst's best estimate of future events. And to juxtapose against that, the retrospective approach, this is an analysis that's performed after the delaying event has occurred, such that the actual sequence, timing, and resources of the work related to the event are known. And then referring to the American Association of Cost Engineers definition, they say, retrospective analyses are performed after the delay event has occurred and the impacts are known. The timing may be soon after the delay event, but prior to the completion of the overall project or after the completion of the entire project. So the prospective approach looks forward in assessing the effect of a delay, whereas the retrospective approach looks backward, looking at what actually happened. So the first question would be, why would you use a prospective approach? So you could, for example, in a contract, specifically provide that delay claims are to be assessed prospectively, but this is unusual. So the contract that gets closest to a prospective approach is the NEC, which says that a delay to the completion date is assessed as the length of time that, due to the compensation event, planned completion is later than planned completion as shown on the accepted program. So it's looking forward towards completion in the future. But the question is, does this mean that under the NEC claims always have to be dealt with prospectively? And I'll refer you to a case a bit later, which provides a bit of guidance on this. Now, time barring provisions require claims to be made and adjudicated as early as possible, often before the effects of the anticipated delaying event have been felt. The SEL Delay and Disruption Protocol, it's a protocol that's published by the Society of Construction Law in the UK. There was an original protocol in 2002 and then a revised protocol, substantially revised protocol in 2015. The 2002 protocol advocated for the time impact analysis method as the preferred method for delay analysis in all cases, and that's a prospective method. The 2015 protocol now adopts a more pragmatic approach. It uses time impact analysis for contemporary analyses, but it recognizes that this may no longer be appropriate for time-distant analyses where the effects of the delay are known. And it's important because the SEL Delay and Disruption Protocol comes up all the time. Delay analysts love using this protocol. But it's important to have regard to what has been said, and this is an Australian case about the protocol. It says the fact that a method appears in the protocol does not give it any standing, and the fact that a method which is otherwise logical or rational but does not appear in the protocol does not deny its standing. So what are the policy considerations that favor prospective approach? Good construction project management practice requires certainty. Claims for time and cost should be finally determined as soon as possible. The contracts provide for claims to be made and adjudicated contemporaneously. so that the program can be updated and everyone has clarity as to the dates by which they are expected to perform. To give business efficacy to the contract, it's argued that the extension of time provisions should be interpreted to imply the use of a prospective approach. The two approaches lead to different results and uncertainty, anomalous consequences, with some claims being determined prospectively and some retrospectively. Support for a prospective approach may be found in the Walter Lilly case, where Judge Aiken had said, in the context of this contractual-based approach to extension, one cannot therefore do a purely retrospective exercise. What one cannot do is to identify the last of a number of events which delayed completion and then say it was that last event at the end which caused the overall delay to the works. One needs to consider what critically delayed the works as they went along. Put another way, it did not delay the works until it emerged as a problem that needed to be addressed. So it looks like a prospective analysis with a retrospective reality check. Another case, the Flower case, judgment by Mr. Justice Edward Stewart, also an English judgment. This was a claim for the recovery of time-related costs, not for an extension of time, but in passing, an observation was made. The judge said, there's been an extensive debate about the correct approach to delay analysis. Mr. Morgan said, and I would accept, that a prospective analysis, in other words, considering the critical path at any particular point in time is viewed by those on the ground at that time, does not necessarily produce the same answer as an analysis carried out retrospectively. The former is the correct approach when considering matters such as the award of an extension of time, but that is not the exercise with which the court is concerned in this case. I agree that some form of retrospective analysis is required. This case is often used by contractors in support of a contention that when the claim is to be assessed during the course of the works, it should be assessed prospectively. So I thought it may be useful to provide some practical or concrete examples of how the two approaches differ in a particular case. So assume for the moment this is an actual example from a real project. This is a very long arbitration that I was involved in that particularly involved a decision by the arbitrator on whether the prospective or retrospective approaches was the correct approach to follow. Now, what we had is it was a convention center project. We had what you see here is a bar chart. The red line demonstrates what the contractor thought the critical activities would be in its baseline program. So it allowed a certain period of time for the structure. So all of the different floors that had to be built, cast concrete, cast concrete, and then once the structure was complete, the roof would be built on top of it. And once the roof was complete and the building was watertight, commissioning all of the complex electronic and electrical systems within the building could take place. And at the end of commissioning, you'd have what I have there as PC, practical completion. Now, one of the activities that the contractor had to do was to install the lifts and the escalators, and that is what is you see there as the vertical transport system. So the contractor originally planned that the vertical transport system would take about 3 months to install, and it would be able to install that whilst the structure was being constructed. So what I've indicated there as float is in fact a period of time between the end of the vertical transport installation and the start of commissioning. And we can see that the vertical transport activity can be delayed by quite a long time before it impacts the start of commissioning. So that's what we refer to as float. Now, during the course of the works, there was an instruction which resulted in a significant additional work having to be done by the contractor to the roof. A much more complicated roof was specified, but it was specified at a period of time long in advance of roof works starting. So whilst the contractor was busy constructing the structure for the building, an instruction was given for that the roof would have to be different, and the contractor put in claims at that time prospectively because the contract said that it had to, and these claims were then assessed and ultimately were the claims that went to arbitration. Now, the prospectively impacted baseline program, you'll see the structure is still the same amount of time. The vertical transport activity, at the time of this assessment, the contractor considered vertical transport hadn't started yet, and it considered that it would still be able to do it within the 3 months period. And what the contractor thought at the time was that the roof would take twice as long. So there's what I have there as ER delay is the additional time on account of the employer's risk event that the contractor thought the roof would take. And that additional time to the roof would then push out the start date for commissioning and thereby push out the date by which practical completion for the works could be achieved. So as at the point of assessment, which is that vertical line that you see on the left-hand side of the bottommost graph, that's the point at which the contractor assessed it. And at that point, it thought that the date by which it could achieve practical completion would be extended by a time period equal to the additional time required for the employer's risk event. So what the next slide shows you is a comparison between the contractor's assessment prospectively, which is I've just repeated the previous graph we had, and I've compared that to actual as-built progress. So by the time we got to the arbitration, this project was almost completed. And in any event, by that time, what we found was that the structure with the roof and the additional work to the roof took as long as the contractor thought. But the vertical transport activity, the lifts, were a complete disaster. And what happened was the contractor had thought originally that it would be able to complete the lifts in 3 months, but actually the contractor took almost 2.5 years to complete the lifts. And final commissioning could not happen until the lifts were complete. So if one then constructs a retrospectively assessed as-built critical path, what we see in the bottom line is that the critical path switches from the structure in the roof to in the middle of the structure activity, it actually switches to a vertical transport. And then it remains with vertical transport for the remainder of the job. So what you see is that the float that previously was after vertical transport, you now have float after the roof was completed, because the vertical transport activity became the activity with the longest time duration. And that was the activity that actually influenced the date by which the contractor could achieve practical completion. So viewed prospectively on that case study, the contractor would be entitled to an extension of time commensurate with the additional time required for the amended roof construction. But viewed retrospectively, the contractor has no entitlement at all to an extension of time, because the critical path to completion actually ran through the vertical transport activity, which was a contractor risk activity and which wasn't impacted by the variation that had been instructed by the employer. So it shows one that, firstly, it's incorrect to assume that one may, as often it will be contended by a contractor, that there's no real difference between a prospective and a retrospective approach. And a retrospective approach is a lot more work. So they normally say, no, look, there isn't a big difference. Well, in fact, there is a big difference because what you are actually looking at is different. You see, this is where the tie hits the road. The difference between the effect of a prospective approach and a retrospective approach arises because you are considering different facts. So in the top graph, what I have here for a prospectively impacted baseline program, what you see in yellow is the facts that are known to you at the time when the contractor puts in the claim. And one can see that what you don't know is what the contractor's actual performance is going to be on his planned program going forward. Whereas with the retrospectively assessed as-built critical path, all of the facts right up to the achievement of practical completion are known. Now, most contracts provide have an arbitration provision that allows for the claim to be determined de novo. And the arbitration process is neither an appeal or a review. In White Constructions, this is an Australian case, the judge said that the court is concerned with common law notions of causation. The only appropriate method is to determine the matter by paying close attention to the facts and assessing whether White has proved on the probabilities that delay in the underboring solution delayed the project as a whole, and if so, by how much. And then we've got the Steam Collier's case, where Lord McNaughton said, if the question goes to arbitration, the arbitrator's duty is to determine the amount of compensation payable. This was a damages claim. In order to enable him to come to a just and true conclusion, it is his duty, I think, to avail himself of all information at hand at the time of making his award, which may be laid before him. Why should he listen to conjecture on a matter which has become an accomplished fact? Why should he guess when he can calculate? With the light before him, why should he shut his eyes and grope in the dark? So that is very strong support for a retrospective approach. And I think what one sees as a matter of practice in adjudications and in arbitrations is that because lawyers are accustomed to look at matters retrospectively, lawyers generally tend to deal with matters retrospectively, whereas often when construction professionals deal with construction claims, they are used to, in their practice, to deal with those claims prospectively, and they tend to adjudicate matters on the same basis. So there's a natural bias, I think, which I mean in a completely neutral sense, simply because decision makers tend to use the tools that they are most familiar with. Now, one of the most recent cases on the prospective retrospective debate is a case from the Northern Ireland Queen's Bench. This case actually involved the NEC contract, which is generally regarded as the most prospective contract of the lot. And what the court here said was, this dealt specifically not with an extension of time, but with a claim by the contractor for costs. Evidence from timesheets and other material of what the consultant actually did in that period, particularly with reference to the change in instructions, is not only relevant evidence, but clearly the best evidence to assist the court in calculating the compensation to which the consultant is entitled. Therefore, the answer to the second question posed by the parties is yes, unless the court as tribunal is precluded from looking at the actual time charges by reason of the contract. So what happened here was, it was a consultant that put in a claim contemporaneously for work that had to be done in future. So there was a variation instruction for additional work, and what he was required to do in terms of the contract was to put in a claim and to quantify what that claim would be worth. That claim wasn't ultimately accepted, and when it went to decision in the High Court eventually, the argument was whether the amount of additional cost should be determined with reference to the date upon which the contractor put in the claim, in other words, an estimation of what the future work would be, or whether the court could have regard to the work the contractor actually did to determine the amount of additional compensation. Now, because he did the actual work long after he put in the claim, the contractor argued that those facts could not, in terms of the NEC form, be taken into account of because a prospective approach was required, and that prospective approach was rejected. So the court said, applying that test here, the defendant contends that the contract is open to two possible constructions, but if so, I prefer the construction which is consistent with business common sense. That is, that the information as to the actual time and cost expended by the consultant should be made available to allow this court as tribunal to fairly assess the compensation event. I consider it a strained and unnatural interpretation of the contract to rely on the use of the word forecast in clause 63 to prevent access to the best evidence in a situation such as this, where the forecast is in reality a claim for work that has been done by the time of the quotation on behalf of the consultant. So ultimately, it is a factual question whether the contractor has established an entitlement to time or cost under the contract. And I would submit that factual questions have to be determined with reference to the best evidence available. If the parties intend the arbitrator to ignore relevant evidence in the determination of the factual question, this would have to be something which is very clear from the provisions of the contract. Prospective analyses generally favor the contractor, as these assume that the contractor will meet the rate of progress dictated by its program, but it can also arbitrarily prejudice the contract. A prospective approach may subvert the agreed risk distribution of the contract, whereby the employer becomes responsible for contractors' risk delays. So in that previous example that we used with the vertical transport activity, which is a contractor's risk activity, if you follow a prospective approach, then the contractor, effectively what happens is that the risk in the vertical transport activity shifts to the employer, whereas in terms of the contract, that risk is squarely rests upon the contractor. It's difficult, if not impossible, where several claims are made by the contractor at different points in time, to reconcile the effects of various delays where every claim has a different program, a different critical path, and a different point of assessment. At the moment, for example, Damien and I have a set of claims, I think it's about 160 claims for delay, which the contractor wants assessed prospectively. But these claims all overlap. So how do you, in presenting a case for an overall delay, present 160 different programs, 160 different critical paths, when all you need to do, in fact, is to have a look at what actually happened on the project and determine what the delay actually was. So conclusions on the correct approach. I would suggest that claims for time and cost should be assessed with reference to the best evidence available. During the project, a prospective analysis may be the only feasible approach given the information available, but on arbitration, a tribunal is unlikely to adopt a prospective approach where the full benefit of hindsight is available. And then lastly, suggestions to advisors and parties, particularly in the context of claims on account of COVID. Firstly, careful analysis of the particular standard form within the context of the governing law of a particular jurisdiction is required in order to determine what a contractor's rights are on account of a COVID-related event. Institutional employers who use a number of standard forms cannot seek to impose a uniform policy of how COVID-related claims are to be addressed. Claims under standard forms for additional time and costs are usually dependent on compliance with strict notification and claim submission requirements, which have to be carefully observed, failing which claims will be time barred. And then generally, it's better to advance properly substantiated claims supported by appropriate contemporaneous records and, where possible, on the basis of a retrospective assessment of the delay and cost suffering, since these claims have a better prospect of being accepted by the engineer in the first place and will in any event have better prospects of success on arbitration in due course. Now, it has been said in the past that there are three requirements for successful claims in construction: records, records, and records. And I think within the context of COVID-19, the pandemic, and the effect that that has on a construction operation, proper contemporaneous record keeping is critical to the successful prosecution of claims. Thank you. Over to you, Damien. I think you're muted, Damien. You're muted.
Thanks, Johan. That was excellent, very informative. I see there's a number of questions and answers in the Q&As that maybe you want to pick up while I continue. And obviously for the third day running, I find myself after an eminent barrister who's given a marvelous presentation, and I asked myself once again, how do I follow that? And I similarly asked myself, why do I put myself up for these things? However, it's a very good learning experience, and again, I thank the foundation for the opportunity to present today, and for the opportunity to listen to David Brimore Thomas, Chantel Humphreys, and Johan Byers. I do learn from each of them all every time I do listen to them. I just basically wanted to just assist in terms of the delay and quantum expert's role in respect of the issues that Johan has talked to just before handing back to him, so he can deal with your questions and deal with any other issues that arise. And obviously, Johan had talked to the prospective and retrospective analysis, and obviously he's raised various issues. I just wanted to talk to the form of analysis, really, and that's what I'm going to talk you through. In terms of my own preferred position, I'm often very much in favour of the Australian case that Johan had talked to, and I often take the viewpoint that in respect of matters of delay, it's very, very difficult to divorce the facts from the contract. And I'm not a big exponent of the prospective analysis because sometimes I think it gives an impressionistic form of analysis to delay. And as I mentioned yesterday, I'm very, very conscious in respect of my work as an expert, not contradicting myself between one set of opinion that I may give in respect of a certain matter to opinion that I may give in a totally different matter. So in terms of my slides, okay, how to prove your delay claim. Obviously, the first thing is the contract. Does the contract require a prospective or retrospective analysis? The facts, identify the total periods of delay to the project and the key periods when delay occurred. Consider the use of an as-planned versus an as-built comparison, which is one of the favoured processes that I like to take on. In terms of the facts, identify the delay events by using factual witnesses and identify both employer and contractor risk events. And I think that's important, definitely in the wake of the COVID situation. The apportionment of risks was probably fairly apportioned pre-COVID, because obviously we relied on the words of the force majeure clauses and the impossibility and the frustration and all those other issues. Very much seems to me, as I mentioned on our first masterclass, is that in the post-COVID situation, foreseeability basically means that the contractor is potentially at risk for everything that is foreseeable from COVID, and that's a separate debate which Johan, Chantal and David would probably enter into on different grounds. And David did mention the challenges of foreseeability and delay moving forward, and for me it's definitely an issue. Facts, obviously, identify the critical path. Delay experts always talk to critical path, and we always jump on the critical path, and people are always very keen to demonstrate critical paths and see which is the most important aspects of a critical path and where those events sit. But critical paths are just simply determined by the physical and technical reality of the project, and making a cup of tea or replacing a tyre on a car have their own critical path, and if you will walk your way through that, then that's obviously occasionally the most easiest way to explain a critical path. The facts demonstrate that delay events that you rely upon caused an actual delay to the completion date, and that goes back to my point there in respect of you can't divorce the facts from the form of analysis. Contracts, review the other relevant provisions in the contract, such as the serving of notices, and there's some questions in respect to the Q&A. The apportionment of liability. Johan has talked to risk between employers and contractors. Concurrency, which is a debate that we all like to talk about, and perhaps there's another conversation to be held under the Foundation's webinar series when we do talk to concurrency, and we also talk to potency and dominancy in the respect of the COVID situation, because it probably seems to me that COVID in certain aspects will become a dominant delay, or the most potent of delays in the concurrent situation. The but-for analysis, I'll talk to that a little bit more. Delay risk allocation and others that lawyers generally impose. When we had a debate yesterday in terms of lawyers and their roles in the construction industry, but they are generally there for the best purposes of the clients that they serve. Retrospective, well, Johan's explained, it seeks to ascertain the actual effect of a delay event based on what in fact happened on the project. It can only be carried out when the project is completed or once the effect of the delay is passed. And we've talked on that in respect to the contract provisions. I'll briefly touch on it, but not to the same extent that Johan has dealt with. If the effect of a delay event is ongoing at the date of the required analysis, then use retrospective to that date, then adopt prospective for necessity. And we've talked to that in terms of the forms of the contract and what they talk to. But to be successful, you need to complete a factual and common sense investigation into what happened. And that is the key of expert work. I mean, diverging from those factual and common sense approaches where experts tend to unravel themselves. Prospective, that seeks to ascertain the probable future effect of a delay event based on the date when it occurs, and it does have its role in construction matters and the resolution of claims and disputes. When a claim for extension of time is made during the currency of the project or the live period of the project, and the principal agent, project manager or engineer will have to consider the prospective analysis submission. And there's some debate in terms that prospective analysis ought to be accepted in certain instances to avoid any prejudice being suffered by the contractor. It can transpire that prospective analysis is wrong when compared with what happens. Now, you know, the good cops, bad cop scenario that we talked to yesterday and we talked to on Wednesday as well, that you know, people work with their best intentions. They you know, the good guy, bad guy scenario we talked to, it doesn't necessarily exist, and contractors aren't deliberately misleading employers. It is their best efforts at the time. But obviously the retrospective does safeguard against that approach. And the test of traditional causation may not be satisfied when used as the basis for a prolongation claim, and Johanna's talked to that as well, and I talked to it briefly. NEC prospective, well, I'm in accord with Johanna. It seems to, the contract itself seems to require prospective analysis during and after completion, but Northern Ireland has an executive case which was explained by Johanna, required a retrospective analysis because they wanted to deal with the actual facts of what actually happened. FIDIC and prospective, well, it seems to require a prospective analysis in notification, but after the effect has ceased requires retrospective, and we must comply with that approach. The delay event, well, what are the delay events? It's an explanation of how the delay event constrained an activity, and then the explanation of how the impact of the constraint evidences causation of delay to the activity or a series of activities. And we talked to critical paths, we talked to multiple critical paths, we talked to fragnets, and we get ourselves all confused with all these issues, but keeping to the facts of the matter, the event which has been constrained, how it affects the activities, can be a simple approach as long as we stick to a common form of analysis. When we talk to a constraint, what is a constraint? Well, a constraint may be physical, it may be a resource, and it may be a constraint at the contractor's preference. But the constraint must constrain a specific work activity, and that work activity must suffer a specific impact. The activity may suffer an impact such as delayed start, prolonged duration, both or a combination of both, and we've seen that in the light of COVID, and it constrains the next specific activity until completion. The repeating process of a constraint and its impact through a series of linked activities to the completion date will prove causation of a critical delay, and we'll see that in analysis. The activities impacted by the constraints will be on the critical path, and we're back to critical path again. In other words, to evidence substantiation, the activities must be on the critical path, and that's a separate debate in terms of whole delay analysis, but let's take delay analysis as being activities which are affected, and those activities are the activities which sit on a critical path. What cures and remedies are available? Well, we've talked to the notice, and it talks to prospective and assessment along the lines of time impact analysis. So I just want to run some samples now in respect to the time impact analysis, and this is on a very high level basis, just so you can appreciate what Johanna's explained in respect to those two processes. Johanna talked to the Society of Construction Law, which has its own protocol and disruption for delay and disruption, and the time impact analysis sits within there, so it's one of the approved in their protocol, and whether that has any attachment to contracts is very much a moot point, but I have seen it more and more that reference to the SCL delay and disruption protocol is required in forms of substantiation of certain analysis. Time impact analysis involves introducing delay event subnetworks into a logic link based program and recalculation of the updated program using the critical plan method. Often it's done by software, and that determines the prospective impact the delay event would have on the then predicted completion dates. The baseline program for each analysis can be either a contemporaneous program or contemporaneously updated baseline program, i.e. an updated program, and we know that from the use of the NEC in certain contracts. The difference being the revised contemporaneous program may have logic changes, activity, resource changes from the original baseline program, and therein lies the whole debate for delay experts in terms of which logic changes should be accepted. In either case, the analyst needs to work with the baseline program, historical components, and reflect the actual progress. So mitigation and acceleration already incorporated into the baseline program need to be considered, as these can often conceal or distort the projected impact of the delay events. And obviously various jurisdictions talk to acceleration, constructive acceleration, and where they sit. But let's just not enter into that debate at this point in time, and let's go on the basis that the updated baseline programme takes account of them. Number of delay events being modelled has a significant impact on the complexity and cost of deploying this method. So, of course, my example is going to be a fairly simple example, not the complex one that Johan introduced. And the product of this method analysis is a conclusion as to the likely delay of the modelled delay events on the critical path that is most reflective of the contemporaneous position when the delay events arose. The method usually does not capture the eventual actual delay, because that would be retrospective, which is caused by the delay events. So let's just look at this, and I'll try to get through this so we can take some questions. The as-planned programme sits with a series of activities, and we have completion. Each of these as-planned activities has a critical path running through it, as we can see here. So we update the programme with actual progress, and we can see that we're slightly behind when we look at activity D there. We reschedule the progress programme, which obviously takes account of the delay that we had at activity D to give us an impacted completion date. And in this example, we say that the contractor is culpable because it was his progress. We then input the delaying event, and the delaying event sits at the end of activity C, which is not dissimilar to Johan's example. And what does that do to our programme? Well, we impact the programme, we move it on, and we can see that the impacted completion date gives rise to an extension of time. Now, we talked to culpable delay from the contractor, an extension of time arising from an employer event. This can be used as benchmark assessment until such time as the full effects of the virus are determined, if that was the case, when this applies specifically to the COVID situation. And then we can look to a windows analysis, which is talking to our retrospective scenarios. Again, this sits nicely within the framework of the Society of Construction Law. So where your contract provides for analysis on such accounts, then this would be of assistance. Similarly, it's a good source of reference and good practice in respect of methodology. The windows analysis refers to periods of time in the project programme, and this could be days, months, weeks, or months. And sometimes these windows analysis on mega projects and long-term projects may stretch over 60, 70 months in terms of window analysis, and the analysis will have to be completed in each of those periods. There's been a move more recently in terms of experts trying to agree narrower periods in terms of windows, but often it's very, very difficult to separate the granular approach with what almost appears to be a global approach. Shorter projects, monthly windows would be used, and quarterly periods may be used, which are 3-month periods, or bi-monthly, which is a 2-month period. Once the window periods are agreed, the analysis can be undertaken to analyse what happened in each window and at the time an event has ceased. Various methods sit within the SCL. I don't need to repeat that, but let's just have a look at it again now then. So similar format to what we looked at before, but we're doing this retrospectively rather than prospectively. Divide the programme into windows or time slices, and you see that we have 3 here. We then impact the delaying events in the first window. We reschedule the programme. It gives us a revised completion date, and we can see our extension of time. We then look to the second window and we impact any delaying events, and we see that there's a delay event in activity C and in activity E. We follow the same process. We reschedule the programme, and we find completion dates after the second window provides for a second extension of time, or an extension of period. Let's not talk to this being all contractual entitlement. Impact the delaying events into the third window. And when we do this, we again take the process of rescheduling the programme, and we can see that our programme period is extending out in the same way that Johan's period extended out. And we see the completion date after the third window. We see that we have 3 particular situations in terms of entitlement which have given rise to the extensions of time or the extended period on the project. And in respect to the merits, that's where our erstwhile and advocates will argue in respect of entitlement. Prevention, well, I just want to touch on these points because Johan may want to touch on them. Prevention is the long established principle of law where one party to a contract is prevented from performing it by the act of the other. He is not liable in law for that default. Now that's difficult in these COVID times, and you know, it's unsurprising that authors of contracts obviously find it difficult to list every event which may have an impact on the contract, and force majeure clauses normally contain a list of events, and you know, they now contain a new list of events, and there's the addition of the word pandemic and COVID. But generally, there's a sweep up phrase, which is any other cause beyond the contractor's reasonable control. Now, I don't intend to enter into a debate with Johan, because he's the superior being in respect of in respect to the law, but some commentators would state that it's not clear whether a jus dum generis rule applies here, as in whereby general words are interpreted by reference to the surrounding words, and whether that principle applies to force majeure clauses. And that may be something that you all want to deliberate. I took some guidance from the Lebopan case, where it basically said any cause not under the control of the party. Whether that helps in force majeure or doesn't help in force majeure, we will see as more and more authorities and more case law arises in the wake of the COVID pandemic. That expression, or that authority, was taken from Home versus Guppy and was used again in Dodd versus Churton in some old English law cases. Concurrency, we wouldn't be anywhere with delay analysis unless we mention concurrency. And concurrency is generally described as a period of project overrun which is caused by two or more effective causes of delay of approximately equal causative potency. Now, I think we'll see some shifts in this in respect of the COVID situation, and it may be that COVID becomes a potent delay or a dominant delay, or it may be that it is purely a concurrent delay alongside some of the bigger issues on construction projects. That was a quotation from John Marin, Queen's Counsel in the UK in 2002. Okay, so finally, the two final points that I sort of mention is that if it's not possible to pass the but-for, which is the but-for an event happening, if it's not possible to pass that but-for test on the normal causation principles, then the delay would have occurred in any event. And I leave that as an open-ended question, which Johan may touch on in some of the answers. And my final issue there for the legal minds amongst you is that if the but-for test is not used, then the contractor recovers time and money, or the employer recovers liquidated damages, which would appear illogical to me. Thanks very much for listening. I'm going to hand you back to Johan. If any questions arise for me, then I'm more than happy to re-engage. But for now, I pass you back to Johan, and thank you very much for that.
Thanks very much, Damien. Thanks for that excellent presentation. Damien, we've got a number of questions here. I don't know if you can see it on your screen.
Yes.
Do you want to deal? Do you want to show? You want to go and deal with the first? I've dealt with some of them, but maybe you may want to address that first one by. Yeah, have you got it in front of you?
Mr. Gupta, is it?
Yep.
Okay. Is it not the right time to consider incorporating the events like the present pandemic in the standard forms of contract? Well, you know, we've had some debate on this, and we had some debate in terms of foreseeability on it. And I definitely think in terms of the pre-COVID situation, the many force majeure clauses in standard contracts didn't actually talk to pandemics. The case that I referred to, the Lebopan case, that talked to epidemics on the strict interpretation of the words, which is why that case, the Lebopan case, has its place in history or in case law. Obviously, needed to turn on the actual attention to the words which precede and follow it. So the epidemic will now be changed to epidemics and pandemics, and standard forms of contracts in the post-COVID situation, definitely from an employer point of view, will seek to provide against the COVID pandemic and seek to place that as a force, not necessarily as a force majeure event, but definitely something that contractors will have to safeguard against. The difficulty is, and definitely for me as a delay analyst and a quantum analyst, is that I'm quite clear that employers take the position that delay analysis is now defunct because everything with any regard to the COVID situation. I'm not sure to the extent that everything can be foreseeable now, because we are in a changing landscape, a changing environment, and we're learning all the time what COVID is doing to construction contracts. So yes, I agree that it's in the post-COVID situation, the contracts will will be amended, not necessarily by the contracting bodies, but definitely by the lawyers acting for part of those contracts, and we will see a change in contract. Prolongation of contract is called in legal time, but basis is for the calculation of claim for contracts claim. Well, maybe you can assist me with those words there, Jan, and we can debate.
I think I may have. I'm not sure whether I actually attempted to type an answer to just maybe if I can and ask Mr. Money to just provide us a little bit more context. Then we'll go on to the next question for the moment, and then come back to that one. The next question is Mr. Nakro's question. Many projects suffer from continuing delays, which results in most activities becoming critical. Under these circumstances, would global claims be admissible? Now, just my view. It is necessary to continuously maintain a proper program so that you understand what is happening on your project, which activities are critical and which are not. I do not consider that a global claim is an acceptable recourse for a contractor that hasn't done that. And save in relatively exceptional circumstances, my thoughts would be that a contractor would not be entitled to put in a global claim if it is possible for the contractor to actually justify in respect of each claim event what the cause, what the effect of that event was. Perhaps more an issue for Damien to consider from a quantification perspective.
Yeah, I think my general approach to delay claims is to avoid global claims. And yes, they do have a role where granularity and particularization cannot be made, but I think that role comes after you have extinguished every opportunity to particularize. From my point of view, I think that claims in the main are capable of particularization and avoid the global condemnation, so to speak, that you will ordinarily receive. And I think the big danger of global claims is that you run a risk all the way until the arbitration tribunal decides in respect of whether your claim is of a good foundation or not. My advice in all respects is to avoid global claims, to particularize where you can. If you can't, to make your very best efforts to disentangle all the issues, prevent you from particularizing, avoid the global claim situation.
We have a question from Sean. Afternoon, Sean. Nice to see you present. Sean raises the issue with the case by the New South Wales Supreme Court decision of White Construction, the one that I referred to in my talk, and he says, this is a reminder that the opinion of an expert programmer alone, whether based on one of the methods in the protocol or otherwise, is no substitute for direct evidence of the actual cause and impact of the claim delay. It's definitely something which I think is the correct approach that should be followed if it is at all possible. I don't know what your views are.
I wholeheartedly agree with you, and I agree with the finding of the judge in that case. Really, I mean, I've been before arbitrators before who clearly do not like the prospective approach, and it's not an approach that I take. But I see my opposing expert criticised in that regard, that they often can't match the prospective approach to the factual approach. My approach in respect of whether it's claimant or defendant is very much on the actual causes and the impacts of the claim delay, and to granularize that to the best of my possible ability. And I am very, very clear with the people that I engage with to say that if the facts of the matter are that you are culpable for a period of delay here, then you have to accept that in terms of your claim and your position moving forward. And the big thing is not to divorce the facts and find a contractual or prospective method which starts to presuppose a different result or a different determination in respect of delay analysis.
Yeah, I agree with that. It's very easy for an advocate cross-examining an expert whose analysis does not take account of what actually happened on the ground to criticize that analysis. You can criticize it on so many levels. You can criticize the analysis, the prospective analysis itself on a prospective basis by saying that the time estimations in the program were never, for example, accurate because the time that was actually taken was more. You can criticize it with reference to the fact that if it differs from what actually happened on the ground, it is theoretical and there must be a reason why there is a difference, and that reason cannot be an employer's risk reason. So it's very, very easy to disrupt in cross-examination what an expert says if the expert's analysis hasn't taken into account what actually happened on the ground.
And pity the expert who exposes himself to that position.
Yeah, that's true. And a lot of experts don't realize the trouble that they will be putting themselves to when they do that. It's absolutely true.
Okay.
Right. I don't think we have any more questions.
Thank you all the panelists. I think we have reached to a final pace. That was really interesting and informative. And the feedback link is served right now in the chat box. You can fill it up now and then. I would like to hand over to Mr. Shahrukh, Managing Committee of KFCRI, to initiate the concluding remarks.
Thank you so much, Shanmugadev. And once again, I would like to express my gratitude to Mr. Johan Bayers and Mr. Damien James for imparting such a plethora of knowledge in such a short span of time. So it has been a great 3-day session, and we are almost towards the end of the 3 days masterclass on construction arbitration and delay analysis in the COVID scenario. All the 3 days have been really engaging and interesting. And before we move on to the end of the session, I would now like to invite Engineer S. Sivaraman, who is the Secretary General of the Indian Institution of Technical Arbitrators, to give a few words regarding the concluding remarks. Please, sir.
On behalf of Indian Institute of Technical Arbitrators, I want to say that our members are fortunate to have participated in this webinar meeting. Many of our members have appreciated through chats, and we find that all the experts had a pragmatic approach to the topics, and we have gained knowledge. And we had some international exposure of what is happening on, especially COVID, and also the delay analysis. The delay analysis have been dealt with very clearly, and we thank all the 4 speakers, and we thank the KFCRI for arranging this with our association. Thank you, one and all.
Thank you, sir. Thank you so much. Thank you for your kind and encouraging words, sir. I would now like to invite Mr. V.Inbavijayan, the project advisor and backbone of KFCRI, to propose the vote of thanks.
Thank you, Shahrukh. It is always a wonderful closing remarks what we are going to share when it comes to joining hands with the Indian Institution of Technical Arbitrators. Now, today I'm really happy that Mr. Damien James, who has really spent his valuable time sharing with us all the entire aspect about the construction arbitration and delay analysis. First of all, wholehearted thanks to Mr. Damien. Thank you for it. And I also intended to thank Johan Bayers. I think in earlier days of my practice, I used to follow the Keating Chambers advice on construction arbitration. And now I'm very happy to host one of the prominent persons of Keating Chambers. And thanks on behalf of KFCRI for wonderfully sharing the very basic concept about the delay analysis. Thank you, Mr. Johan. And on behalf of KFCRI, I'm very much happy to host the other 2 speakers, Mr. David Bremer Thomas, QC, as well as Chantlin ma'am. And this session, which would become a dream and happen only because of my good friend Anish Vadia. I think today he couldn't continuously join and facilitate it. Thanks, Anish. And on behalf of KFCRI, the message what we wanted to bring by this masterclass on construction arbitration and delay analysis in the COVID-19 scenario is that this particular sector, the construction dispute arbitrations, is a sector where we have to seriously get involved. And if this arbitration is being effectively administered, not by an institutional administration, by the ad hoc mechanism wherein the stakeholders, if they are going to be effectively managing this or administering this process, whether the councils or the expert, obviously the liability would all be equally shared by the employer as well as the contractor. And with these few words, I feel that the construction arbitration is going to be the future prospect of arbitration practitioners as well as experts. And as young students and engineers who are getting involved in arbitration, the takeaway from this 3-day masterclass is that the role of various professionals in this particular process has to be seriously administered. And if it is being seriously administered, the outcome is going to be the success. It's all about conflict management. Very simple. The conflict management at the right point of time with real professionalism is the need of the hour. Thank you. Thank you for Mr. Damian James and his colleagues as well as the barristers. Thank you.
Thank you.
Thank you so much, sir. Just like what Mr. Inbavijayan just expressed, this has been a dream come true for KFCRI in conducting this 3-day masterclass. And it is an overwhelming fact, which I have to mention, is that on all the 3 days of the session, we had maximum participation from all the attendees. And in fact, the maximum participation in Zoom was filled, and we also had attendees who joined the session through Facebook Live. So it is really overwhelming that such a great participation is expected, and it is definitely because of the luminous panelists who enlighten these sessions. So before we conclude, a bit of logistics to all the attendees. So the feedback link is already sent in the chat box. So just like what the procedure was followed on day 1 and day 2, you are requested to duly fill in the feedback form, and also send us that you have attended the session on all 3 days. So once we cross-verify your participation on all 3 days, we would send you the payment link and other details, and then the e-certificate of participation would be processed. KFCRI is upcoming with various activities, events, and trainings and webinars in the upcoming days. To be regularly updated about KFCRI, you can stay connected with us on all social media sites such as Facebook, LinkedIn, Instagram, and YouTube. And if you have any other queries, you can also write to us at kfcri.adr@gmail.com. So once again, thank you all the attendees, and thank you panelists for the enlightening session.
Thank you.
Thank you.
Thank you all.